Thank you for visiting the Waterkotte website and our Death Penalty Lawyer in Missouri website page. Regardless of the crime, we believe everyone is entitled to the best possible legal defense in the state of Missouri. We have created this audio version of our website page to help you better understand our services and protect your future, freedom, and reputation. If you have been charged with a capital crime in the state of Missouri, we can help. Don't face the state and court system alone during your capital crime charge. Contact one of our Missouri capital crime defense lawyers today at 314-900-HELP to protect your rights and future. Waterkotte is committed to handling all capital crime defense cases with confidential care and understanding. We are not here to judge you. We believe that everyone in Missouri, regardless of the crime they have been charged with, deserves an aggressive legal defense and to have their legal rights protected. With that being said, let's discuss hiring our capital crime defense lawyers in Missouri and setting up a free consultation with our attorneys. Capital Crimes and Death Penalty Lawyer in Missouri. Capital crimes are the most serious offenses in Missouri, carrying life in prison without parole or the death penalty. The prosecution devotes massive resources to securing convictions, and mistakes in legal defense can be fatal. Waterkotte provides aggressive, trial-tested defense for those facing capital punishment anywhere in Missouri. If you or a loved one is facing capital charges, act now. Call our saint. Lewis Criminal Defense Lawyers at 314-900-HELP for a confidential, no-obligation consultation. What are capital crimes in Missouri? A capital crime is any offense that qualifies for the death penalty under Missouri law. While all capital crimes are Class A felonies, not all Class A felonies qualify for capital punishment. These are the most serious criminal charges, reserved for offenses deemed particularly heinous or premeditated. Protect your freedom and your life. Call Waterkotte now at 314-900-HELP. In nearly all cases, a crime must result in death for prosecutors to seek the death penalty. This means that, except for treason, RSMO Section 576.070, first-degree murder, RSMO Section 576.070, is the only crime that can lead to the death penalty. How is the death penalty decided in Missouri? In Missouri, if someone is convicted of first-degree murder and the death penalty is on the table, the judge or jury must go through a specific process to decide whether the person should be sentenced to death or life in prison without parole. Prosecutors must prove at least one aggravating factor beyond a reasonable doubt, listed below. If an aggravating factor is proven, the jury or judge will then decide if the overall case justifies a death sentence or life without parole. The jury must consider all evidence, including anything that might lessen the punishment, mitigating factors like mental illness or lack of a criminal record. If a jury is involved, the judge will not tell them which specific evidence counts as aggravating or mitigating. Each juror decides for themselves. What can make a murder a death penalty case? Aggravating factors. Not every conviction for first-degree murder is eligible for the death penalty. Missouri law requires that the jury finds the state proved one of 17 aggravating factors, beyond a reasonable doubt. The defendant has a history of violent crimes if the person was previously convicted of first-degree murder or another serious violent offense. The defendant committed more than one murder if the killing happened while committing or attempting another homicide. The defendant put multiple people at risk if the murder was carried out using a weapon or device that endangered multiple lives, e.g., a bomb or mass shooting. The murder was for money if the defendant killed someone for financial gain or to collect money for someone else, The victim was a public official. If the victim was a judge, prosecutor, elected official, or law enforcement officer and was killed because of their official duties. The defendant hired a killer or was a hired killer if the murder was a murder-for-hire situation. The murder was especially cruel or gruesome if the crime involved torture, extreme cruelty, or depravity. The victim was a first responder if the victim was a police officer, firefighter, or peace officer killed while on duty. The defendant was in custody or had escaped from jail. If the murder was committed by someone already in prison, jail, or police custody. The murder was committed to avoid arrest. If the defendant killed someone to prevent their own arrest or to help someone else avoid being caught. The murder happened during another serious crime. If the murder was committed while carrying out rape, sodomy, burglary, robbery, kidnapping, or a major drug-related felony. The victim was a witness if the person was killed to stop them from testifying in court. The victim was a prison employee or inmate if the victim was a corrections officer or inmate killed in a prison or jail. The murder happened during a hijacking. If the victim was killed during the hijacking of a plane, train, bus, or other public transportation. The murder was meant to cover up another felony if the defendant killed someone to hide another major crime. The murder was meant to stop a criminal case if the killing was done to prevent someone from reporting or helping prosecute a crime. The murder was part of gang activity if the crime was committed as part of an ongoing criminal street gang operation. If at least one of these 17 factors is proven beyond a reasonable doubt, prosecutors can seek the death penalty. If none of these factors apply, the maximum sentence is life in prison without parole instead of execution. What can avoid the death penalty? Mitigating factors. Even if the jury finds an aggravating factor, they must also consider mitigating factors, circumstances that might lessen the defendant's responsibility and justify a life sentence instead of execution. The defendant has little to no criminal history. The defendant was under severe emotional distress when the murder happened. The victim willingly participated in the act, rare but possible. The defendant played a minor role in a murder committed by someone else. The defendant was forced or pressured into committing the crime. The defendant had mental illness or cognitive impairments that affected their ability to understand their actions. The defendant was very young at the time of the crime. Even if an aggravating factor is present, the jury must weigh all mitigating factors before deciding on a sentence. If the jury cannot unanimously agree on the death penalty, the sentence is automatically life in prison without parole. Charged with a capital crime? Your life is on the line. Call Combs Waterkotte at 314-900, help for an aggressive legal defense. How capital offense trials work in Missouri. Under Missouri Revised Statute, Section 565.030, prosecutors can decide to waive the death penalty, and the case proceeds like any other criminal trial. What happens if the death penalty is being considered? If prosecutors seek the death penalty, the trial happens in two separate stages: guilt or innocence trial. The jury, or judge, decides whether the defendant is guilty or not guilty of first-degree murder. If found guilty of a lesser homicide charge, like second-degree murder or manslaughter, the case proceeds like any other felony sentencing. If found guilty of first-degree murder, the trial moves to Stage 2. Sentencing trial, death penalty, or life without parole. Prosecutors present evidence of aggravating factors, such as multiple victims or extreme cruelty. The defense presents mitigating factors, such as mental illness or lack of criminal history. The victim's family may provide impact statements about how the crime affected them. The attorneys argue whether the defendant should be sentenced to death or life in prison without parole. The jury, or judge, makes the final sentencing decision. When the death penalty cannot be imposed in Missouri, the jury, or judge, must sentence the defendant to life in prison without parole if the defendant is intellectually disabled, proven by medical evidence. The jury does not find at least one aggravating factor beyond a reasonable doubt. The mitigating factors outweigh the aggravating factors, meaning the defendant's background, mental state, or circumstances justify a life sentence instead. The jury decides not to impose the death penalty, even if aggravating factors exist. How the prosecution builds a death penalty case in St. Louis. Prosecutors aggressively pursue the death penalty in Missouri, using all available resources to secure a conviction and the maximum sentence. Their approach typically includes high-profile, resource-heavy investigations. Capital cases receive extensive law enforcement attention, often involving multiple agencies. Extensive use of expert witnesses. The prosecution relies on forensics, psychiatry, ballistics, and digital evidence experts to strengthen their case. Confessions, witness testimony, and DNA evidence, statements from the accused, eyewitnesses, or forensic evidence are key to securing a conviction. Push for the harshest sentence possible. Prosecutors will emphasize aggravating factors to argue for death over life without parole. Common defenses against capital charges in St. Louis. Because the stakes are life and death, an aggressive defense strategy is essential. Some of the most effective defenses in capital cases include wrongful accusation, mistaken identity. Many death penalty cases are built on weak forensic evidence or unreliable eyewitness testimony. Establishing an alibi or alternate suspect can undermine the prosecution's case. Self-defense or justifiable homicide. If the accused acted to protect themselves or others, the killing may be legally justified. Mental health, competency, defense. If the defendant suffers from severe mental illness or intellectual disability, the death penalty may be off the table. Illegal police practices. If law enforcement used coerced confessions, unconstitutional searches, or violated Miranda rights, key evidence can be thrown out. Not guilty by reason of insanity. The defense may be able to demonstrate that you did not know what you were doing when you committed the act, or did not understand it was wrong. Execution versus life without parole. What happens after conviction? In Missouri, capital crime convictions can lead to either execution or life without parole. Both are severe but offer very different outcomes. Death penalty. Lethal injection is the primary method. Lethal gas may be requested. Death row inmates held in high-security units. Executions scheduled by Missouri DOC. The process often takes years due to appeals. Life without parole. Permanent incarceration. No release. Maximum security for life. Limited privileges and movement. No risk of execution. Clemency possible through the governor. How we challenge death penalty cases in St. Louis. Prosecutors will do everything in their power to push for the maximum penalty. But at Waterkotte, we fight back with proven defense strategies that can weaken their case or avoid the death penalty if convicted. Weak forensic testing? Unreliable DNA? We challenge every piece of prosecution evidence. Eyewitnesses often misidentify suspects, and jailhouse informants are highly unreliable. If your rights were violated, We fight to suppress illegally obtained evidence. We work with forensic specialists, psychologists, and criminal investigators to dispute the prosecution's claims. If a conviction happens, we fight to present every mitigating factor, such as mental health issues, lack of prior offenses, or extreme emotional distress. Why choose Combs, Waterkotte for your St. Louis? Death penalty defense lawyers. When you're facing a capital charge, you need more than just a defense attorney. You need an elite legal team that knows how to win high-stakes cases. Combs Waterkotte brings experience, strategy, and relentless advocacy to every capital case. We know how to challenge capital murder cases in high-stakes trials. Our legal team has successfully defended serious violent crime cases, including first-degree murder cases. Capital crime charges require immediate action. We're available anytime to start building your defense. Facing a death penalty case in St. Louis? You need the best defense possible. Call Combs Waterkotte at 314-900-HELP or contact us online now.